Hi, everyone. For those who don't know me, my name is Philippe Boisvert, and I'm a partner at BLG here in Montreal. And I want to say just a few words today in my capacity as one of the ICC YAAF representatives for North America. I know there's another representative in the room today. I see Stephanie Clark. So there's a couple of us. There's three of us for the whole country. The ICC Young Arbitration and ADR Forum, or ICC YAAF, is a network of professionals 40 and under, providing training and mentorship for the next generation of arbitration lawyers within the ICC structure. We organize events like today's panel on a regular basis all around the world. For those of you who would like to get involved in ICC YAAF, you can become an ICC YAAF member for free by signing up online, and you can also apply to be a regional representative for the next term. It's been a pleasure, as always, to work with our good friends at YCAP to host this event.
Thank you, Philippe. It is always a pleasure for YCAP to collaborate with the other young organizations, including ICC YAAF. On behalf of the Young Canadian Arbitration Practitioners, I just wanted to welcome you as well to our joint event. As you know, YCAP was founded in 2004 by some of the people in this room with the aim of promoting interest in arbitration, as well as the understanding of arbitration among the members of the legal community, as well as creating opportunities for educational and professional development and networking opportunities for younger members of the profession. Our membership spans throughout Canada and outside Canada. We have currently more than 200 members, and we're very active, especially when it comes to putting on events on not just the CanArbWeek, but also New York Arbitration Week, Paris Arbitration Week, London International Disputes Week. The events that you can look forward to that are upcoming will take place in Vancouver for the ADRIC conference, as well as our fall symposium, which will take place in Ottawa. And none of that would be possible without the tireless work of our wonderful Vice President of Education Events, Ekin Sinar from Dentons, to whom I yield the floor now to introduce the moderator of today's panel.
Thank you so much, Nyam. Thank you all. Good afternoon, everyone. My name is Ekin Sinar, and I am, like Tina mentioned, the Vice President of Events for YCAP. And it is my pleasure to welcome you to today's session and introduce our moderator, Dayeon Min. Dayeon is a lawyer at BLG in Montreal, where her practice focuses on international arbitration and complex cross-border disputes. She regularly acts as a lawyer in high-value commercial and investor-state disputes. And these matters are in a range of industries. Dayeon is called to the bar in both Ontario and New York and holds civil and common law degrees. Please join me in welcoming Dayeon Min and the panel for today's session. Thank you.
Thank you, everyone. Thank you for still being here while we're standing between you and your 5 p.m. drink. It's very appreciated. And I'm glad to be discussing with you today, or revisiting, we should say, the topic of effective writing and witness statements. I think it's a especially fitting theme for a YCAP panel or an ICC YAAF panel, as often when you start as a junior associate, drafting a witness statement is often the first drafting experience that you get in an arbitration proceeding. And before we get to the topic, I would like to introduce to you our very seasoned group of practitioners here to give us practical insights and perhaps share some crunchy, interesting war stories with us. So I'll start with Vasuda. Vasuda is a partner at McCarthy Tetro's National Litigation Dispute Resolution Group. Her practice is focused on complex commercial and investment arbitration and litigation, as well as cross-border jurisdictional disputes. She has extensive experience appearing as counsel before various international arbitration tribunals, such as ICC, SCC, UNCITRAL, and ICSID tribunals, as well as the Supreme Court of Canada. Prior to joining the firm, Vasuda has practiced for nearly a decade at the Freshfields Paris office. Next, we have James. James is a bilingual litigation and disputes partner at Gowling's WLG's Ottawa office. His practice focuses on commercial litigation as well as arbitration, both international and domestic, as well as intellectual property litigation and administrative law. James has argued before the Supreme Court of Canada, the Federal Court of Appeal, and the Federal Court, as well as all levels of Court of Ontario. James is certified as a qualified arbitrator by the ADR Institute of Canada and acts as arbitrator in commercial and IP matters in both ad hoc and institutional settings. And last but not least, we have Martin Martin. Martin Valasek is co-head of Bennett Jones International Arbitration Practice Group. He is a leading practitioner in the area of international arbitration with extensive experience in both investor-state and commercial disputes. He regularly acts as counsel and also sits as an arbitrator. Martin's experience extends to legal assistance on all continents and covers a wide range of industries, including energy, mining, construction, forestry, aerospace, banking, and manufacturing. And Martin has also started his career somewhere else in New York City and has worked in various leading international law firms before joining Bennett Jones. So thank you, all three of them, for being with us today. So before we get into the discussion of actually drafting the witness statement, I'd like to discuss with you the very first procedural step going into the arbitration proceeding, the PO1. So Vasuda, do you have any considerations that you have when you prepare or you draft the PO1 with regard to the production of witness statements?
So I should say that my experience on this is coming from cases where the tribunal is pretty experienced and or has the benefit of the institution behind it and provides a draft PO1 that is relatively complex and thought out in terms of its basic content and structure. And so the question is, well, what's in there that we need to think a bit more about, or what's not in there that we need to think about? And a lot of the strategic consideration that I do when it comes to POs of that sort, PO1s of that sort, is informed by experiences with members of my own team and members of the opposing counsel team coming from different jurisdictions, where initial reflexes about what the purpose of a witness statement is, how we engage with witnesses for the hearing, and for the arbitration more generally differ. And so it's trying to get ahead of thorny issues before they arise. And so with that context in mind, some stuff that I like to think about going into a PO to head stuff off at the pass include including a requirement that the first set of witness statements are complete. Some counsel, some jurisdictions tend to be selective and, let's say, judicious in the inclusion of information in the first round, have a tendency to sit on their hands, lie in the weeds a little bit on key information to see if it's going to come up, and then only thereafter be more forthcoming. And whereas having grown up in a common law litigation environment where you're drilled in with this concept of full and frank disclosure or including all relevant stuff right out of the gate, that's not intuitive to me, and so there can be an imbalance in the approach of counsel. So that's something that I think about. Another issue is the consideration of whether witness statements are coming in different languages or if they're all coming in English. And if they're coming in different languages, how the translation issue will be dealt with, whether they need to be submitted at the same time, whether a delay is possible between the original language witness statement being submitted and the translation following. Another thorny issue relates to the inclusion of documents or the reference to documents in a witness statement. Again, having grown up in litigating in Toronto, my inclination had always been to ensure anytime there was a witness who was referring to a fact or a document, to have that documentary support attached to the witness statement, clearly referred to in the witness statement. That's not everybody's instinct and can create imbalance. And so having that requirement either stated or not stated, one way or the other, but having the clarity on the issue has been helpful. And I like to have a little bit in PO1 related to hearing logistics. People have different views about that. Some people like to wait until we get closer to the pre-hearing conference to get the witness-related PO1, witness-related procedural order rules set out. And I think for the sake of clarity, it's helpful to have some of that stuff set out at the front end. It can always be adjusted later on if need be, but a little bit of structure I find to be helpful.
Thank you. What say you, Martin?
Well, first of all, it's so nice to be here and to see so many familiar faces. So thank you very much for inviting me. I thought, with respect to PO number 1, I think most tribunals and parties are quite comfortable with the IBA rules on the taking of evidence, and I think it's just worth noting that a lot of PO1s will sort of shortcut a lot of the debate and discussion over some of these details by either incorporating the rules by reference, and that could be just as guidelines, or sometimes the parties want to be more directive to the tribunal. And it's just worth looking at the IBA guidelines, which I happen to have on my desk, and I pulled them, and they do deal with some of the thorny issues that do otherwise need to be worked out, including who could serve as a witness. So helpfully, the IBA rules say that any person may present evidence as a witness, including a party or a party's officer, employee, or other representative. And we know that in some jurisdictions, in some legal systems, that can be somewhat controversial, whether you can have everyone who is potentially has relevant information serve as a witness. Similarly, and I should say this is obviously in Article 4 of the IBA rules on the taking of evidence that deals specifically with witnesses of fact. Similarly, it shall not be improper for a party, its officers, employees, legal advisors, or other representatives to interview its witnesses or potential witnesses and to discuss their prospective testimony with them. So that's a very gentle way of saying it's okay to prepare witnesses. Now I know that we have, we'll have some other questions about that. And so in my experience, and then there's obviously, I'm going to skip over some things, but then there is the specific content of what each witness statement should contain, and there's a reference to the full name and address of the witness, a full and detailed description of the facts, and so on and so forth. My point is that what I've sometimes seen is where parties aren't necessarily referring directly to the IBA rules on the taking of evidence, tribunals will often cut and paste some of this and put it into their PO because it frankly provides a very nice code for witness evidence, and it already takes into account, to a large extent, differences in traditions and tries to strike a reasonable balance. The one additional point I would make, maybe, which sometimes is addressed in greater detail, is what if the tribunal decides to call a witness that neither party called? And I haven't seen that happen very often, but in principle, a tribunal has that power. And then what happens then? When should a tribunal give notice of that? Does that mean that witness will prepare a witness statement? So that's often dealt with. I would say that I think it's paragraph 10 of the IBA rules of Article 4, paragraph 10 says that at any time before the arbitration is concluded, the tribunal may order any party to provide for or to use its best efforts to provide for the appearance for testimony at an evidentiary hearing of any person, including one whose testimony has not yet been offered. A party to whom such a request is addressed may object for any reason and so forth. But the question sometimes arises is whether that witness will provide anything in writing in advance and provide some notice of what that testimony may look like. And that's sort of an interesting topic to cover or to raise for for procedural order number 1. Then the other, maybe the last thing I would say, and it's somewhat of a pedantic point, but of course it makes everything a lot easier, is just formatting and labeling and numbering. We know that in large arbitrations in particular, things can get complex and there can be many witnesses and many sequential numbers. And so sometimes, well, not sometimes, regularly, tribunals will have very specific requirements for how they want everything numbered. And that could include how they want specific witness statements referred to, what you do when you have numerous witness statements from a single witness over time, and sometimes there can be up to 3 or 4, depending on whether you had a jurisdictional phase, and then that was joined to a merits phase, and then you had so you could have 3 or 4, and some very complex arbitrations go to 3 phases if you also have quantum. So you can have cases where you have numerous witness statements from the same witness, sometimes covering overlapping but separate topics. So, I think a procedural order should turn its mind to that in a complex arbitration, so that everyone can quickly see which witness statement is being referred to as opposed to just Mr. Smith's statement. Mm-hmm. And then when it comes to documents, sometimes tribunals also like to have documents referred to with the prefix of the witness who referred to them, and so on and so forth. But all of that should be covered in the procedural order number 1, so that it's all nicely organized right from the start.
Thank you. I think for the details of the numbering and the exhibits numbering, it's part of the detail that often partners might not think about necessarily, and that's when really your role as an associate on the file, who will have to be numbering maybe those exhibits late at night, comes in to remember there's things when you're drafting the PO1. So it's those really little details that kind of matters as an associate when you're drafting the PO1. So after we got the PO1 nailed down, when it gets to choosing the witnesses and choosing the right witnesses for writing your statement, James, what would you say are the main considerations that you have when choosing which witnesses to interview and to write a statement for?
Well, thank you. So, to me, this point isn't necessarily that different from court proceedings. So just like in court, you have to think about who's going to be best placed to give the particular evidence that you want given. As we all know, in arbitration, the rules of evidence are often significantly relaxed, which gives you a lot more leeway as to how the evidence goes in. But I always try to remind myself that the rules of evidence aren't just arbitrary, right? They developed over time to promote fairness, and they a lot of common sense, right? And so I think to take hearsay as an obvious example, hearsay is often going to be admissible, or a lot more admissible in arbitration proceedings than in court, but you still want to think about how much hearsay you want to shovel into somebody's witness statement. So once you figure out who would be, in a perfect world, giving whatever evidence you need given, then you have to get a bit more practical. And I've noticed, I don't know if you guys have noticed as well, tribunals putting a lot of emphasis on efficiency and limiting, hearing time where possible. And so, where you, in an ideal world, would have maybe one witness giving, compartmentalized pieces of evidence on each different topic, it might make sense sometimes to centralize some more evidence with a single witness. And that actually happened recently in a case that I had. It was a complex construction case, and we made a strategic choice to put a lot more of the evidence in one kind of higher up employee's witness statement, knowing that they had just a broader command of the overall factual matrix, rather than splitting it out into smaller witness statements. And this ended up being a point of contention. Opposing counsel said, well, there's a lot of hearsay here and so forth, but we made a strategic decision to go that route because that person would have frankly been best placed to withstand cross-examination on a broader scope of topics. And so these are, again, the strategic decisions that you're going to want to make in the case. And in document-heavy cases also, this is another thing. A lot of commercial cases, as we all know, are very document-heavy. You have a lot of business records. Is it that important that the author of each email give evidence on their emails? Probably not. In some cases, maybe. And you have to make those calls. But I generally try to take a step back and think about who's going to be best suited in a broader sense to give the evidence that we need.
What about you, Martin?
Well, first let me start with a kind of a preliminary thought, which is I think this is, for me anyway, one of the funnest parts of what we do, which is meeting the individuals who know about the facts and having that first opportunity to hear from sometimes a wide range of people involved in the project or employed by or owning the business in question or involved in the technical question. And it is, I mean, at the end of the day, so crucially important in my view. I do think that a lot of cases do come down to documents, of course, but those documents will be interpreted, will be commented on by witnesses at the hearing, they'll be cross-examined on them. And I just really find this a fun part of what we do, in addition to the whole legal side. And I agree with you, James, that you obviously want to try to get people, I mean, there's some obvious points here. You want people who have the direct knowledge of what happened, but that's, when you look at it more closely, you might have 3 or 4 people who have direct knowledge, and the knowledge might be a little bit different from different perspectives, different levels of seniority who perceive things very differently, and there's some very important choices to be made. And then, of course, if you put everyone in thinking, well, we'll cover all the angles, then there's a lot of opportunity for discrepancies, maybe on minor points, but things that will take a disproportionate amount of attention at the hearing, depending on how they're cross-examined. So anyway, I find this a really interesting part of the exercise. And I do think that ultimately you're largely evaluating a witness's ability to withstand cross-examination. If you think for international arbitration, fortunately, unfortunately, I think for efficiency's sake, it's fortunately, but for the witnesses, unfortunately, they don't really get a chance to tell their story in direct testimony. And over time, I've really struggled with this in international arbitration. I have felt that a case may have turned out differently if ultimately a witness may have had a couple of days to kind of introduce themselves to the tribunal, comfortably ease their way into telling their version of events, not just in a witness statement, and we'll get into all the, the parts about how you craft that together to some extent. And because they don't have that opportunity, maybe after a very short confirmation of the truth of their statement, maybe some adjustment to a paragraph because their lawyer pointed out that there was a mistake, in one of the paragraphs. Boom! All of a sudden, they're being cross-examined, and therefore, your exercise in evaluating witnesses, yes, is in part what do they know and how are they going to present it, but largely through the eyes of how are they going to withstand cross-examination. And that turns a lot on their own ability to articulate what issues are. I mean, frankly, there is an intelligence component to it. Are they going to be able to sort of see what's coming or what the cross-examiner is getting at? Are they going to be able to to identify it? And that's not something that you can, the more you coach a witness who doesn't have certain innate abilities, the more that could backfire very significantly. So to the extent you can evaluate those things and you have some choices, then I think you do go for the witnesses who are likely to just present, not be overly stressed by it, are going to be able to give good testimony on cross-examination. Just recently I met with, right now, I just happen to be in the process of reviewing a lot of different potential witnesses. And, we just recently met with 2 individuals who own the business, and both are lovely people, absolutely lovely. They're 2 different generations. But my associate and I came out of the meeting saying, wow, that person is a lot warmer than we thought, and they would really come across as lovely in the hearing. But then we realized on cross-examination, the more senior of the 2 would never be disciplined, could just never, ever stick to, listening to the question and actually just limiting the potential damage that cross-examination could do. They would be lovely at telling the entire story, and that person would absolutely have the tribunal wrapped around their finger. But because they're not really going to get an opportunity to do that and are going to be directed through cross-examination, you sort of try to limit the downside as opposed to maximize the upside, I feel. And so that's just, one thing to consider. And I mean, maybe a final point, I've been involved in a number of cases where inevitably the argument comes up in closing argument of the empty chairs. Like, who wasn't here? Someone always tries to raise, if not a formal adverse inference, then at least sort of an informal adverse inference that, someone wasn't here. How come we didn't have the CEO of the company? After all, this is a $50 million case, and the CEO doesn't even, bother coming here to tell the tribunal what's happening. And so there's always, I think you always have to be aware of the empty chairs risk that people will, it's just an easy argument to make. Like, why is the senior person whose name appears on all the minutes of this, that, or the other, on all the letters, or, and why aren't they here? And sometimes the answer is sometimes the honest answer is that they just are too busy with other things and they just cannot go through. If they had, if they were involved in litigation as a professional witness, essentially, they wouldn't get anything else done. And I just recently had a meeting where we went through that and we kind of anticipated, what those objections might be, and we were sort of coming up with ideas for how we could resist that kind of, light adverse inference which was being sought. But in other cases, I think it's fair to say that you're trying to avoid, maybe one of those personalities who's very tough to control and may well be difficult to control for a cross-examination. And I think ultimately that gambit can end up working. Like at the end of the day, when the arbitrators are considering the evidence, they're ultimately considering the evidence that was presented to them, especially with respect to witnesses. It's very hard to say that you should draw a formal adverse inference, especially if someone else has addressed the issues and has given a position. So you can't just say you don't have any evidence on this, and so therefore you have to draw the adverse inference. No, we've got a witness, they were perfectly fine. And so you often see not quite the most senior people, but the sort of next level who will step in. And I think that that's fine in many cases. Anyway, I'd be interested to hear, what people's experiences with that. But I find that really a fascinating dynamic.
So right, you mentioned the adverse inference. I really hope the arbitrator, in the case I'm about to talk about, thinks about this the way that you do, because I had the exact opposite situation. So we put in a higher level executive person to give a lot of the evidence, and opposing counsel, and this is not an exaggeration, has sought 27 discrete adverse inferences because we failed to lead a lower level on the ground employee. Oh, can you hear me now? Yep. A lower level on the ground employee, and they say, well, this person was a former employee actually, and this person's within your control, and you could have brought this person as a witness. First of all, so could they, incidentally. But 27 adverse inferences I now have to respond to on the train ride home.
So once we select that star witness, that quasi-perfect witness, often as a counsel, when you sit down with them, the facts are fresh to your mind, but the witness might not necessarily have as a fresh memory of the dispute or the facts of the matter. Vasuda, when you get to that first talk, how do you interview witnesses without influencing or distorting their memory according to kind of the version of the facts that you would like to have in the case?
I think, is that on?
Yes.
Yeah, okay. My first interview with a witness is always completely, I call it discovery style, like an uninformed discovery, in terms of just asking super open-ended questions, not prompting any responses. I try to avoid showing documents on the first set of interviews too. I also just like to understand what their perspectives are and what their responses are going to be. And I know at that point we'll, as the counsel team, have seen some documents, we'll be able to assess that witness's memory as against the documents and whether they align or not. But I don't like prompting memory or refreshing memory at that first interview, because I just want to understand instinct and personal recollections. And it's only with subsequent interviews and meetings that I think it's helpful to then start with documents and prompting memory refresh to really understand where that recollection fits in with the case theory that we are expertly dreaming up on the side.
What about you, James?
So I agree with all of that. I have in the past, though, actually provided some key documents to the witness ahead of the meeting. I'm thinking of a franchise dispute that I dealt with a few years back where so much of the case really turned on one email chain. And I thought it would be good to just allow this person actually to refresh their memory about this, because I didn't think it would necessarily be fresh in their mind. And then rather than going to it directly in the meeting, I approached it very much like Vasuda. Let's just talk about this. Let's talk about the case. And then it kind of naturally came up, and he had a copy printed off, and he pulled it out, and then he started taking me through it, which was nice because I didn't have to lead him through the evidence that I was hoping that he'd be ready to give. But I generally agree a discovery type approach is the best. You want to avoid putting a fact pattern to the witness, because some witnesses will say, no, that's not exactly how it happened, but some might inadvertently or otherwise kind of fall into the grooves of your suggested narrative, and that could end up backfiring pretty bad on cross-examination if that ends up making its way into your witness statement and you go down that path.
Can I just make a quick point?
For sure.
On some of the advantages of being very open-ended early on, and obviously don't want to identify cases and so on, so I'll just be very generic. But it was an investor state case, and I find in those types of cases, you are dealing with some government conduct under NAFTA, you were often dealing with Canadian government contact, so you had a better understanding of how the system works here. So if you were representing a foreign investor, it wasn't as difficult to get a handle on what was going on in country X. But if you're dealing with a Canadian investor or foreign investor in a foreign country that you haven't lived in, that you don't know a whole lot about, obviously you usually have local counsel there, but getting as much information, including information that's a little bit off just maybe the very specific points that you think you want to get from the witness, is very helpful. And I'll give an example. Interviewing a witness and just letting them go, like letting them sort of just explore different things that they felt were relevant. And you're looking at your watch and you're wondering how long this is going to take because they were involved in the investment for a long time. But then all of a sudden they start to give you some insight about a meeting with a particular minister way back when, and then how it really works in that political system and so on. Like I never would have dreamt of asking like this particular line of questioning, but all of a sudden a whole new way of looking at what may have been motivating certain things. And I think in some measure, large or small, that applies to any dispute, because you don't know what you don't know. And so how do you learn what you don't know? You give people an opportunity to tell you. So it's only once you ideally identify everything that you should know, including what you previously didn't know, that you can then start moving more directly. But some of that is a privilege of having time. Sometimes you don't have time. So if you are a little bit more constrained, obviously you do need to cut to the chase and go for the what is much is very important.
And just because this is a YAAF and a YCAP event, I think just thinking back to when I was more of a kid, I continue to be a kid, but when I was a younger kid, I would always be very nervous about asking questions that suggested that I didn't know something that I thought I should know. And I think getting rid of that instinct has only helped me. Because you can't be expected, particularly in your younger years, but even not, you can't be expected to know everything about everything. And if you ask your witness a question and you get an answer and they refer, and this has come up more times than I ever would have thought, they come up with an answer related to, for example, Turkish gift-giving culture. And you think, what the heck is that? But you don't want to sound culturally insensitive, so you just move on. But actually that ends up being a key issue in the case. You're much better served at that first meeting to say, that's interesting. Tell me more about Turkish gift-giving culture. And that will really serve you better as your case goes on, to understand the perspective of that witness and the key issues in the case. And you don't actually sound like an idiot if you ask about something that you don't know, if you're quite honest about your interest in whatever the answer is. So I think that's an important tip for our junior friends, is don't be afraid of what you don't know, embrace it, and just use it as a learning opportunity.
So to the point of, interviewing a witness for the first time, I think it's also really important to remember that establishing a rapport with your witness is key, in the sense that the friendlier you are with the witness will be more comfortable in the interview and will give you details or bad parts of the story that he or she may not necessarily give. But also, the friendlier you are to the witness might be more engaged and more responsive to your emails, and often when they're busy and a dispute is not top of mind, that can be really helpful in finishing and drafting the witness statement. So being a good and friendly person to counsel might seem basic, but I think it's always important to keep in mind. So moving on to the drafting part. So the IBA guidelines on party representation say that a counsel may assist witnesses in the preparation of witness statements, but we all know that in practice, counsels do a lot of the pen holding. So practically speaking, how do you, James, how do you keep the process balanced between the counsel drafting and the witness giving a meaningful contribution?
So with fact witnesses, I think we all know it's fairly common for counsel to hold the pen. If you've done a good interview or interviews and you have the notes that you need to really sketch your narrative, then I think it's perfectly permissible for counsel to take the first cut at the draft. I mean, you definitely want to keep the witness apprised, lots of comments for them to answer, notes to draft, and keep them very, very involved in the process. But I don't think it's in any way crossing the line to actually hold the pen. It's obviously very different when it comes to experts, but certainly for fact witnesses, I think it'd be pretty inefficient to do it any other way, really.
And what do you say, Martin?
Yeah, I find in an ideal world, the witness would draft their first draft. But you realize, this will overlap a little bit with our last topic, which is how do you put a witness at ease. You realize how blinkered we ourselves could be by the fact that we do this day in, day out, and that it's just part of our lives is preparing for a trial, interviewing witnesses. I mean, for most people, this is a highly traumatic experience. I mean, unless you've got, people who've been through, managers at a construction company or something for whom this is like regular course. But often, even in important arbitrations, some of the witnesses will be experiencing this for the first time. And so one thing that I find helpful before getting to the drafting part, to your point of putting witnesses at ease and being friendly, one part of being friendly is to explain to them exactly what the process is and literally foreshadowing what it will be like to be at the hearing, what the room is going to look like. They have no idea often. And so you're going into it thinking, okay, this is a witness, great. They'll know exactly kind of what I'm doing here. We're preparing a document. But from their point of view, they're meeting someone in a suit, maybe multiple people in a suit, and like, why am I putting anything down in writing, and what's this going to lead to? So I think really backing up, and often we will send, potential witness like a little kit, like kind of like an explanation for what the process is that they're embarking on. It's like a little mini course in arbitration and hearing, so that and all of us are much more likely, when you think of an unfamiliar experience, you're going to be stressed and strained. It's much easier if you know what's coming. So that's kind of one aspect of it. And then the other aspect about drafting is that you will come across witnesses who are just not accustomed to writing something like a witness statement. They just, I'm not saying that you come across witnesses who are illiterate. That, unlikely in most of the cases that we're dealing with, but they just that might just not be the way that they're accustomed to spending their day writing something effectively. In an ideal world, they would. Like, I think in an ideal world, even after the interview, you might say, well, we've covered a lot of points. Can you send me kind of an outline of what of what we've been discussing, so that you have even little turns of phrase or the way they express something. Sometimes I think of the role of the lawyer and the witness, like it should be the witness's voice, and you're like the sound engineer. Like, you're the one who's like tuning the tone and the consistency and getting the noise out and making sure that whoever's listening to that voice will get it nice and clear. And as soon as you take the pen, and I agree with you, in 90% of the cases, maybe you'll, or maybe whatever percentage it is, you will probably start drafting earlier than maybe ideally you should. But then the real challenge is, how do you ensure that it just doesn't sound like the pleading? And then are you going to be, and that could be terminology. It could also, so I really, and sometimes it's just in the notes. Like, if you do have the good notes, then you could, if you could capture some of the ways that they explain something, or the way that they, a turn of phrase, then of course when they're ultimately testifying, that's what they're naturally going to come back to. They're going to be speaking through their voice. And so often you see witnesses whose witness statements are prepared a certain way, and then on cross-examination the voice is completely different. And so, to the point where they've strayed completely off, and so that's the risk. So I think as long as I guess if you're taking the first cut, as long as you're quite attentive to that voice and you're keeping notes not just of facts, but to some extent of expressions and the way they articulate parts of it, and you try to incorporate it, I think that's helpful.
No, totally. And what you're saying is actually, and I've done this, it's a lot easier to do if you're operating with pleadings rather than a strict memorial. Because what I did one time is it was a shareholder dispute, and there were 3 founders of a company, and they were very, very passionate people. And so I gave them the pleading. I said, look, here's a bunch of allegations. Tell me what you think about all of these. And I cut all the swear words out, and then I used that as kind of my template for the first cut of the witness statement. So they didn't draft the witness statement, but I had a lot of their voice in it, and it's a very important point. You want it, to the extent possible, to sound like them. Maybe you punch up the language a little bit here or there, but you don't want to use 13-letter words for somebody who doesn't English is their third language. Let's say it's just not credible.
To the point of trying to make the witness statement not sound like a legal submission, often we want the witness statement to be persuasive, but then it's not a memorial. So, Vasuda, how do you keep the 2 lines separate, so without the witness statement actually merging into a legal submission?
Yeah, to me, the key issue is, what is the purpose of this witness, and keeping that in mind the entire time you're doing the drafting. And some of it also involves being able to say no to the witness when they're inclined to put in everything that they think is relevant, because that creates too much noise. And I've had a case recently where it was a traumatic event for me, because by the end of the hearing, our main witness had 2 witness statements that in total were 220 pages. So you can imagine how much fun the juniors had checking those footnotes before filing. But beyond that, just preparing that guy for cross-examination at the hearing was a month-long affair, because there was so much information. It was like you say, it was actually his memoir, as far as I was concerned. Like, we wrote this guy's life story over the course of 2 witness statements, and that was one of them. I mean, add in the 3 other witnesses, and we had more history than anybody ever wanted. But it was because it was such an important case to these people personally, they refused to let us cut out stuff that we insisted was noise. And there is that balancing act where you can eliminate the stuff that is dangerous, but you will let the stuff that is presumptively innocuous in order to strike that balance. But at the end of the day, we got in front of a tribunal who had that much material from us and somehow even more material from the other side. And I don't think that is persuasive, quite honestly. It was a necessity of that circumstance. So what is the purpose of this witness? What do we really need them to talk about? And how do we want to make sure that they don't get stuck on cross-examination on issues where their credibility would be tested on issues that are not actually material to the case, or are key questions for me when we're drafting witness statements to keep them persuasive.
Anything to add, Martin, or?
Well, I think a lot of it does come back to the earlier point about voice. So if you are, the more you can capture the witness's voice, the less likely that's going to be what your legal submissions look like. Your legal submissions are going to be your voice as advocate, applying the law to the facts, so on and so forth. And of course, we've all been involved. I've been involved in cases where they really do match up. Like the witness statements are just kind of mirrors of the pleadings, starting with the recitation of the facts, but then even some of the exchanges, and depending in a contractual issue, depending on sort of what glosses are coming from the witnesses on the way certain events happened, and you could just see in the pleadings that this is sort of cut and paste in there. Not ideal. I mean, could be an effective memorial or legal pleading, but then, that often will break down if the witness really is speaking to a document that just is a copy of the legal pleading, and it's not their voice. So I think it's the voice issue is really key. Other than that, I think it's also really important to remember, it's a little bit Vasuda's point, keep in your mind that a witness statement is very distinct from the pleading. The witness statement, in order for it to be very persuasive, it should be considered kind of in isolation as to how will the witness defend in cross-examination the material that they've put forward in their witness statement. That is the purpose of that witness statement, and that's what you should be focused on, as opposed to looking at each witness statement to make sure each one is sort of repeating your position. That's not what the witness statement is meant to do. That should all be captured just in your memorial, and that's just useful to keep in mind. Sometimes you want to gild the lily, and if you're holding the pen on the witness statement, it's maybe tempting to add in that little flourish, to conclude a point or something, to make sure that you're repeating the point, so that, we all hear that repetition is important. Well, repetition may be important in your oral argument or even in your pleading, but it's not a good idea to make it obvious that you're just repeating that across a series of witnesses. So that's just kind of easy things to try to keep in mind.
Yeah, I think the repetition between a series of witnesses point is an important one. I had a case a couple of years ago where the other side put in 23 witness statements, which was a lot. And a lot of them were paragraphs lifted from one to the other to the other. And it goes back to the point that James was talking about earlier in terms of witness selection. You really wondered, what is the point of all of these witnesses? And on one hand, we were thinking, like, they must be hiding one of these people behind all of them, right? Because there was no way we were going to show up. Right. Well, but also, like, we weren't going to show up at a hearing and cross-examine 23 people. We had, it was, the tribunal held us to an equal division of time. Not necessarily fair, where somebody put in 5 witnesses and somebody else put in 23. So we weren't going to cross-examine all 23. And if maybe we picked the right one and we got the guy who was overtly lying, and maybe we picked the wrong one and we didn't. But you don't know, right, on the other side of things. So that was a strategic choice on their part that also then frustrated the tribunal, because, and this goes back to the PO1 point, the counsel on the other side insisted that there were certain witnesses who we didn't call to cross-examination who should be able to attend and give some direct evidence, notwithstanding that there was a provision in PO1 about leading with written witness evidence. And so they showed up, and they had 10 minutes of clearly practiced direct. Everybody knew it was practiced, and there was no hiding behind it. And we had no cross-examination of these people because we didn't call them. So they did their speeches for 10 minutes, and we said, okay, we have no questions. And then the tribunal lost its mind because it said, you know, we've only showed up here, like we've booked 10 days of hearing on the basis of 12 witnesses, but you're not actually engaging with 5 of them. What's the point? That wasn't on us, that was on the other side. But it was a frustrating experience for everybody because it was a complete waste of time arising out of an injudicious selection of witnesses, but maybe strategically judicious, and we don't know. But it was a very bizarre experience to have 14 people have the same 3 paragraphs of somewhat relevant but not material evidence, you know, across the board, and you wonder at the end of the day what the tribunal thought of that. I don't actually know.
Yeah, just a small point again on the legal argument point. Of course, you don't put legal argument in your witness statements. This is totally improper. But I also try to avoid even using legal terms of art wherever possible in witness statements. I received one where the witness was talking about a sandbagging clause and actually used the word estoppel. I'm thinking, okay, you know, this is like, you have to at least suspend your disbelief a little bit that, you know, counsel's helping with the, you know. So just, it's best to try to avoid the legal concepts altogether and speak to the facts underlying which you ultimately want to argue. Yeah, estoppel. Mr. So-and-so is telling me about estoppel in his witness statement, yeah.
So because we're in La Belle Province, I'd like to have a bit of a comparative law exercise and tell us a little bit about the differences that you've noticed between civil law tradition lawyers as drafted witness statements versus common law style of witness statements. So Vasuda, if you could comment a little bit on that.
So my experience has to be informed by the French lawyers that I have experience working with, not all civil lawyers, obviously. I think there's a difference in the tone of the narrative. It tends to be a lot more, I'll say, flowery when it is written by French lawyers. I think there tends to be less of an incorporation of documents with the understanding that the documents speak for themselves, and the witness is there to plug the gaps or provide memory recollection. And then when it comes to contract cases, this is an area where I think there is a clash largely informed by the actual law in play. And certainly when I was working on cases with colleagues of mine who were hailing from civil law traditions, one of the battles we would have is whether a witness could talk about what the intention behind the contract was in their witness statement, and they would say, "I sent this email with the intention that this would go into the contract and that this provision meant X." We always say that doesn't matter, but to my civilian law colleagues, it did matter because that's where they were coming from, and so. A lot of the time it's a question of legal education, and that informs the style of writing, but it's also a question of the law that is informing the analysis. And I think, you know, sometimes if you're doing a common law case, but you're a civilian lawyer, checking those instincts and the inverse is important to make sure that your reflexes are in the right direction.
Martin, you have anything else to add on top?
You know, my experience is informed, like many, by experiences maybe at some big firms that already have a mix of traditions. So I'm just trying to sort through the question, and it makes me laugh. Like my first case, I was working at White & Case, and, you know, I was in New York, but the Paris office was the main place where the case was being handled, and so many people had a mix of traditions. Like, it's just, you know, like I'm thinking of the junior associate Charles Nirac, who's both literally French and English. Like I forget which one. I think his father is French and his, you know, mother British. So I can't say that I can, you know, that in my experience I've really been exposed to counsel who are kind of pure on one side or the other. But I would say, you know, from my own experience, which I guess was, you know, I was at McGill, so again, I had common law, civil law, but I'd always understood, and this has only started to change more recently, I'd always understood that if a document, you know, was sort of associated with a witness, that it's that witness who should talk about that document, and that document should be attached to their witness statement. And I'd always kind of come at it by saying, I don't want any documents that are just, you know, floating out there without being attached to a witness. I want ideally to have everything kind of tidied up. And I know that that's a very common law, I think, approach. And it's also an approach informed by sort of this idea that you want to avoid hearsay. So even if it is kind of hearsay in the sense that maybe the witness didn't have direct knowledge or, you know, participation in the creation of the document, at least you've assigned the document to a witness, so you're kind of playing by the rules of introducing evidence in a more traditional way. And then over the course of my practice, I realized that that is just not shared across the traditions, and that some arbitrators are perfectly happy to just have all the documents come in as claimants' documents, and if some witnesses want to speak to them, then just refer to them in the witness statement. But it's just kind of claimants' documents and respondents' documents, and that's I think that's a very civil law, you know, kind of concept of what the documentary record looks like. It's like the documents speak for themselves, and we can read them, and if a witness wants to tell us how they read them, that's fine, but that's not going to necessarily change our mind as to what a document meant. So I don't know if that's a helpful response, but it's certainly my personal experience. And I would just add how relevant it can be, and I do have a war story about it, and I won't go into detail, but where a witness statement is excluded, you're in a whole lot of trouble if certain documents have only been referred to by that witness in their witness statement. In other words, the tribunal, I think the tribunal made the wrong call here, but the tribunal actually said that we are excluding this witness statement because the witness hasn't appeared for a hearing, and there were all sorts of good reasons why that witness was no longer employed by the company and actually asked to be compensated at a crazy amount to come to the hearing, and we disclosed all that. We basically said, look, we don't control this witness anymore. The witness is essentially extorting the client to pay them the severance that they thought they had once been entitled to, but that they weren't. And so we're just, you know what, we just can't deliver that witness. And the tribunal deliberated. They decided to exclude the witness, but they also excluded all the documents that were attached to that witness statement. And they did this after the hearing. So it was kind of a crazy circumstance.
That sounds super fair.
Anyway, don't get me started on that. But I think going forward, my best practice will be to certainly, basically try to guard against that kind of risk and ensure that, you know, all the documents are somehow presented separately and that the witnesses refer to them. And if they do refer to them, there's like a double introduction or something. I don't know. Figure some way out to avoid that risk.
But this is where PO number one can really come in, right? I mean, if you have an agreement that you have a claimant's book of documents, respondent's book of documents, and maybe you have an agreement on authenticity, maybe you don't. But you know, if the cards are on the table at the beginning and everyone's transparent about how you're getting documents in, I think you're less likely to have certainly a crazy situation like that. But even any kind of fight over it, you know, well, this document wasn't proven. If you deal with it all up front, there's less likely to be surprises on the back end.
I'd like to jump to the topic of difference in styles between domestic litigation and witness statements in domestic litigation and in international arbitration. James, in your experience, what are the main differences in style, I would say, in domestic litigation versus arbitration?
To me, the only difference that I can really think of is if you have an arbitrator who's experienced in the subject matter or in the field or the industry, you can assume a lot more knowledge. So if you have, for instance, a construction dispute and you have a witness talking about how, you know, they made up time here and this, you know, generated 5 days of float, you don't need to explain what float is in a witness statement to a seasoned construction arbitrator, right? Whereas if you're in court with a judge who may or may not have background in that area, you might want to, you know, describe concepts or technical aspects of the case more. I've got one case in court right now that involves a very obscure and I think outmoded kind of electrical motor to the point where we're even having trouble like worldwide finding experts about it. So, you know, in describing this technology, you better believe we're going to walk the judge through every little technical word. There will be no acronyms. Everything is going to be set out. Whereas, if we had an electrical engineer arbitrator, even if they weren't necessarily, super dialed in on this obscure technology, they know what a single line diagram is. They speak the language, right? And so that to me is the biggest difference. Otherwise, you're, like we said before, you're telling a story, it's got to be in the voice of the witness, and I don't think the venue or the forum necessarily changes that.
So moving on to the topic of drafting skeleton arguments. So personally speaking, as someone who was trained in a civilist legal tradition, I do wonder sometimes about how useful is a skeleton argument that is filed before the oral hearings, and then there's going to be an opening statement that might just rehash what was just said. So Vasuda, let's start with you. Do you think that skeleton arguments are always necessary, or are they useful at all?
So by skeleton arguments, we're talking about this English style approach of having before the hearing a condensed version of what is basically a roadmap to the oral opening that you're going to give. And in my experience, particularly in commercial cases, if the tribunal is chaired by an English barrister or primarily comprised of English lawyers, they tend to insist on it just by virtue of habit. I think in cases that have gone on a really long time or that have a whack ton of material, there is some value to it because it forces you as counsel to focus on the critical path of your argument, and it forces the tribunal to do the same. But to be effective, I think it really does have to be a skeleton. It's helpful to have a page limit imposed. It's helpful to be very skeletal, to state the obvious, in the drafting of the argument, and just loading it up with footnote references in terms of what is being referred to in the in the pleadings. And then using the opportunity of the opening argument to fill in the blanks and to be persuasive. So I don't think the job of a skeleton argument is to persuade. I think it's to crystallize, and then it's supplemented by the opening argument to persuade.
Martin, anything to add?
Not a whole lot, really. I mean, I haven't come across a whole lot of requests for skeleton arguments before a hearing, and I guess the question that arises for me is, what is the point of the opening then if you've got the skeleton? But you've just explained it well, I think, and of course it could be helpful. I mean, if you're preparing your opening, presumably you've had some version of a skeleton prepared for yourself to kind of prepare a roadmap for how you will present the case. I've also heard, recently in certain meetings or conferences, some people say, well, you just do away with the oral openings. I mean, increasingly, often the oral closings are dispensed with because everyone's exhausted and the tribunal and the counsel don't want to, go through the trouble of having to spend another couple of days and then preparing something that everyone realizes can be done perhaps, more effectively. Query whether that's true in post-closing submissions. But increasingly now I find I'm hearing, well, why have the openings? You can have a skeleton or some kind of introduction, just get to the evidence. And I think oral advocacy is still important, so I would hesitate thinking that the skeleton substitutes for the oral openings. And so I really like your way of seeing it, that if you do present it, it should really not be anything other than kind of a really nice, succinct way of getting people to start thinking about what the main points are, and then the oral opening will sort of fill in the persuasive element of it. Yeah.
Well, now I'm actually just curious, amongst the people in the hall today, how many people have you come across an arbitration where you had to submit a skeleton argument prior to the oral pleadings, just by a show of hands? Okay, so still a fair number.
Did you think it was a waste of time?
Not at all. Not because you have these huge witness statements, and the tribunal doesn't. It's not like a trial often months before the hearing, and the tribunal is sitting there saying, what do you want me to focus on? What is actually in dispute at this point? And it should be clear by then, but sometimes it isn't. So having a sort of reminder, or here's what the case is really about, or here's what to look for, can be really important.
Closing our discussion about written advocacy is from the perspective of a counsel or even an arbitrator or a tribunal secretary. Is there any other new tools or new forms of written advocacy that you would like to raise or bring to our attention? James?
I don't know if it's new, but I think compendiums, book of extracts can certainly be helpful. Chronologies can be really useful, and sometimes, rather than doing a big long chronology, sometimes you'll have a chronology about a specific key issue. And I'm thinking about one of the cases I referenced earlier, where so much turned on who knew what and when about a specific document, like a memorandum that they all signed. And there were, like 17 drafts of it over 18 months, and then there were a bunch of email chains going in different directions, and it was a bit of a dog's breakfast, but it was a lot easier to digest. We created a timeline just with respect to that document, and then it was used in the crosses, and it featured in the closing, and I thought it was really, really helpful. And we didn't need a whole chronology of the case. It was really just that piece that was just like a hornet's nest, and we deconstructed it.
Martin?
So I'll mention three categories. One is just a minor supplement to written submissions, but what's sometimes referred to as the dramatis personae or personae, which is kind of the list of actors or characters in the play. And it's a minor point, but like a chronology, it can be a place that the tribunal and frankly counsel can go to remind themselves, who is that person again? What's their position, and which side are they on, or what's their role? And some cases are we talk about document intensive cases. I mean, some cases are intensive with the number of people involved and players involved. So some kind of glossary or glossary is another one. It's a similar kind of thing. A glossary, dramatis personae. Think about adding that to your case if it's relevant. And sometimes even if there aren't a ton of people, it can still be a helpful piece to put in and not that time consuming. Maybe the second category would be just building on to some extent chronologies and how they're presented at the hearing. I guess it brings up the broader question of demonstrative exhibits generally. And I'm now at Bennett Jones, but previous to that I was with a number of firms that were very involved in U.S. litigation, and I find the arbitration practitioners who are involved with U.S. offices are often accustomed to or have colleagues who do jury trials, including civil trials, and they are much more accustomed to presenting complex cases to lay people. And so their instinct is to, dumb it down or use pictures, and I'm using pejorative terms, but actually using effective demonstrative exhibits is incredible. And now with technology, you can do incredible things. And it could be just as simple as even on a chronology, you can have certain animated features that when you're speaking about something, the sort of relevant issue comes up and so forth. So, and then obviously every possible type of demonstrative, whether it's graphics relating to, often this will be in evidence already. Obviously a demonstrative can't be new evidence, but if you have, certain maps and then you can identify things or graphics relating to the plant, color coding. Recently I was involved in some capacity with a dispute over a large manufacturing facility. And if you're just reading the witness statement or the pleadings, you really have no idea what this thing looks like or what you're talking about. And then the graphics were so terrific, like just showing you the aerial view. And nowadays with drones, people can take amazing pictures of almost anything. You don't have to have a huge budget to do that sort of thing. Consultants can do that. And then you overlay, color-coded presentations that show you exactly what's where, and that can really make a difference for how an arbitrator will understand, what is going on. And then the final category, which I came across for the first time, speaking of skeleton arguments, we had a request for post-hearing skeleton arguments prior to post-hearing submissions, and that was sort of odd. But I think that the tribunal was really, hopefully not confused by our advocacy. I think we've still been waiting for the award, and it's been 2.5 years.
They're confused by something.
And I think it's just it's a very complex case. It is a treaty case with just about every possible objection on jurisdiction admissibility, and then complex merits questions. And I think they were just, I suspect that after their first deliberation meeting, they just said, God, how do we just at least get a handle on how each party sees us getting through this thicket of different arguments, and how, it's kind of a roadmap to a decision, as opposed to a roadmap to the hearing or something, but it was a roadmap to a decision, and I think that helped them. They then formulated questions that they wanted answered in the post-hearing submission. So I think kudos to the tribunal for not trying to play smart and saying, oh, we can't let them know that, we need help with this. And, well, we'll see. I'll let you know next time if I'm happy with what they did. I hope so.
Did you have anything to add, Vasuda?
I'm not going to stand in the way of people and their 5 o'clock beverage.
We are right on time. I would like to open the floor for at least one question. If anyone has a burning question about drafting witness statements, there is the burning question.
Yeah, very quickly. Usually, in my experience, you have one main witness, either the CEO or a shareholder, that has much of the information that you want to put in front of the arbitrator. And I'm wondering, how much corroboration witness statements do you need? Because the opposite party will have a different witness saying, we don't have the same view of this fact pattern, and we don't have the same view of what happened there. And how much do you need witnesses to come and play and to say, we stand by the version that your primary witness gave, and we have the same vision of the story? Do you need 1, 2? Do you go, if there's 10 employees that have the same experience, do you follow the 10 employees and expose them to cross-examination? How do you deal with that kind of situation?
I mean, to me, I think the more witnesses you have available for cross, just the more room there is for a disaster. So, sometimes you want people to corroborate maybe from a different perspective. Well, so-and-so said this, I was there that day, and then I spoke with this person. But, I mean, I don't think the kind of tag-along evidence is really that useful. I mean, obviously, if they're all from the same entity or certainly on the same side of a dispute, I mean, I don't know how much more forceful or probative the arbitrator is going to find that to be, but that's just me.
I think that's right. I think the more important piece is to make sure that your other witnesses, should they be cross-examined on that stuff, actually are in a position to corroborate and not to contradict. So I think testing it when you're talking to those witnesses in preparation is what matters. Putting in the repeat quote-unquote evidence in a witness statement, I don't think is the persuasive piece.
Yeah, so I would agree that sort of quality over quantity generally, and for one reason, it does open you up to potential cross-examination risks in terms of inconsistency. But the twist I would put on it as well is, let's say you have 5 witnesses, all of whom are testifying to an important but different aspect of the case. Make sure all of them know every other witness's testimony. That is so important, because even though they shouldn't be cross-examined on it, I'm not suggesting this is some kind of Machiavellian strategy. It's just, it's just reminding them, what is the total picture here? If you're an actor in Act 1, you should probably know what happens in Act 3. That'll just help you be a better, person presenting that aspect of the case. I don't know what your experience is, but and it's an added burden for witnesses, because it means that they are doing a little bit more than just reviewing their own witness testimony. We usually really try to make sure that they understand what every other witness, what their perspective is. And sometimes that elicits during the preparation. We didn't really talk about this, but it's another interesting way of eliciting corrections or nuances in their testimony, because, one thing is to present documents, right, and say, well, you said this happened, but this letter says that it happened the day before. Are you sure? Oh, check your calendar. You make a correction. Another way of doing that is to show them what other witnesses are saying about certain things. And even though it's not exactly in the same subject, it could elicit comments or trigger memories or whatever it is. So I think that's an important aspect of the process, actually, that's useful that your question prompted.
It is, although there's a point of diminishing returns there. You try to have a witness have everything in their head, and then that could
There
go,
is,
I've seen
yeah.
that go
So
wrong,
I
too.
mean, these are all judgment calls, and so I'm just thinking of one case in particular where that was just really important, that they kind of know what each other's testimony was.
All right, you're now free to go have your 5 p.m. drink. A round of applause for our wonderful, wonderful panelists.